Hello, everyone. Let us begin a new unit, consideration. Now, consideration is one of the most essential elements of a valid contract. No consideration, no contract. See, you cannot have a contract without consideration. You must get something in return, and both the parties, in fact, if there are more than two parties, then all the parties must get something in return. See, if you're not going to get anything in return, there's no basis for filing a case, right? So you go to the court of law and you tell him, I want to file a case. Judge will ask you, what didn't you get in the contract? You said, no, I was not going to get anything, but I just want to file a case. So there cannot be a case without consideration. If you're not going to get anything in return, on what basis and for what will you file a case? So, consideration is one of the most essential elements of a valid contract. Now, consideration means something in return. That something can be anything of value. There is a Latin phrase also for it. An agreement without consideration is void. You cannot have a contract without consideration. There is one more Latin phrase which you can include over here, which is nudum pactum. It means naked promise. That is the exact translation, naked promise, which implies agreement without consideration. Okay, so it means agreement without consideration. An agreement without consideration is void. Consideration means something in return. That something can be anything of value. I give you goods, you give me money. I give you goods, you give me goods in return. I give you goods, you give me services. I give you services, you give me money. I must get something in return. And that something should be of value. You can't say take a stone. No, that stone should be of value. Okay. So I need consideration. Consideration means something which has value. All right. Now, these are the type of questions which are generally asked from this chapter. This chapter is mostly important for theory question. But yes, we cannot deny that if your exam has case-based questions, then case-based questions can also be asked. So we are preparing for different kinds of exam, like an MCQ exam or a case-based question exam or only a theory question. So a variety of exams, they ask different kind of questions, but the content remains the same, act remains the same, concepts remain the same. So if you are you may be preparing for any exam, act is going to remain the same. Okay, so in case of a combination of theory and case based question, this is more important for case for theory questions. Okay, all right. Now, on what concepts or sections are questions generally asked? So you prepare for any exam, every examiner considers these concepts as important. So let us go through them. The first one is stranger to contract. Yes, stranger to contract and its exceptions. Then a question may be asked on the essential elements of consideration, but that is a very lengthy answer. Yes, it is a 6 to 7 mark answer. What are the essential elements of valid consideration? If it is asked in the exam, it can easily be asked for 6 to 7 marks. There is a lot of content to write, but ma'am, we don't have time to write all this in the exam. I'll give you a technique. Okay, explain all the points, but for only the first 3 to 4 points, write examples. Okay, no need to explain the case law, name is sufficient. So just mention name of the case law, you need not explain the case law. Write the theory and consider all the points. Okay, you have to mention all the points. For the first 3 to 4 points, write example also. Then you don't write example, just explain the theory, that's it. Easily you will be able to write around 2 to 2.5 pages, because there is a lot of content which you can write, and 2.5 pages is sufficient for a 6 to 7 mark question. Mike was about to fall. So it is sufficient for a 6 to 7 mark question. Okay, now, stranger to contract and its exceptions, essential elements of consideration. In the essential elements of consideration, this is a very important case law, Chinnaya versus Ramaya. For this, you need to learn the facts and judgment. You may be expected to write this in the exam. Learn facts and judgment. Generally, I don't ask you to learn the case laws. I am okay with you writing in your own words, but in particularly this case law, I request you to learn the facts also. Consideration need not be adequate. This is generally asked as a case based question also. So theory, yes, essential elements can be asked, but this can be asked as a case based question. That is, consideration need not be adequate. Past consideration is generally asked in case based question, but other consideration you're expected to know. Okay, don't just limit yourself to what is important for exam. Conceptually you should be strong. This is just for added benefit. Rest others are not important, so okay, this is fine. Yeah, this again can be asked as a theory question, which I have already made you write. It can be asked as a theory question. From this, covenant can be asked as a case based question. On others, this may be asked, okay, as a case based question. Not very frequently asked till now, but can be asked. Question, case based question can be asked. Validity without consideration, again, very important as theory question. Okay, so here also you will write down section 25 that covers agreements valid without consideration. Agreements valid without consideration. It can be asked as a theory question. You need to write everything. Okay, in that you need to write everything. But if a case based question is asked, this is very, very important. Natural love and affection, case based questions. Again, agreement to compensate for past voluntary service, case based questions. Promise to pay time bar debt. Very recently, they have started asking questions, case based. Earlier, they were not asking question, but now new questions have been framed on this concept. Completed gift can be asked. Charity can be asked as case based. You will be surprised, students. You will be surprised to see that many theory as well as case based questions are asked on this concept. Validity of agreement without consideration, very important for exam. Theory, case based, maximum questions are from this part. Okay, so this is an overview of the chapter. So I have also highlighted case based questions. Okay, I have highlighted the case based question. Now, let us begin our discussion. Consideration means something in return. It is the most important element of a valid contract. No consideration, no contract. Now, let's say, for example, that X offers to sell his house to Y for rupees 10. It's very less. X offers to sell his house to Y for rupees 50 lakhs. If X is giving the house, what is he getting in return? 50 lakhs. So consideration for X is 50 lakhs. If Y is giving 50 lakhs, what is he getting in return? House. So consideration for X for Y is house. Both parties are getting something in return. It's a valid contract. Okay. So consideration means something in return. Both the parties must get something in return. That something can be anything of value. So consideration means something in return. An agreement without consideration is void. Nudum pactum, naked promise, also says agreement without consideration is void. Now let us go through the essential elements of consideration. But yes, before that, we also need to discuss the definition. Students, as always, the essentials can be derived from the definition itself. So section 2 clause D defines consideration. Very easy to remember. Dena, lena. You give something and you get something in return. So section 2 clause D defines consideration. Consideration when at the desire of the promisor. I will first read the definition from for you, and then from that we will highlight the essential elements. When at the desire of the promisor, promisee or any other person, I'll keep highlighting the key points, okay? When at the desire of the promisor, promisee or any other person either has done or abstains from doing, does or abstain from doing, promises to do or abstain from doing something, then such act, okay, then such act or abstinence or promise is called consideration. Now let us read and understand. When at the desire of the promiser, consideration must move at the desire of the promiser. The promisee or any other person, it may be given, it may be supplied either by the promisee or any other person. When at the desire of the promiser, it means that consideration moves at the desire of the promiser. So X offers to sell his house to Y. So it is his desire to sell the house. Money may be given either by the promisee or his relative Z. I am not concerned. I just want money. It may be given either by the promisee or any other person. I am not concerned with that. But the house, selling of the house is my final consideration. It is my final willingness. So consideration must move at the desire of the promiser. It may, however, be given either by the promisee or any other person. So over here, when at the desire of the promiser, now many a times after reading the question, students get confused. Ma'am, we are not able to identify the promiser and the promisee. So please note down, students, that the person who gives the offer, okay, the person who gives the offer is the promiser. And the person to whom the offer is given, okay, the offeree is the promisee. So the person who gives the offer is offerer, promiser. Person to whom the offer is given, that offeree, is the promisee. So when at the desire of the promiser, promisee, or any other person either has done or abstains from doing, okay? So has done, that is the positive aspect of consideration, to do something. Abstain from doing, abstain is the negative aspect of consideration. So to do something is the positive aspect, not to do something, abstain, forbearance, that is the negative aspect of consideration. Has done, this talks about past consideration. Does or abstain talks about present consideration. Promises to do, that is future consideration. Okay, so this has done is nothing but past consideration. Does, that is present consideration. Promises to do or not to do, that is future consideration. Past, present, future. Then such an act or abstinence, this is the negative aspect of consideration, is called consideration. I will discuss positive, negative, but first let us understand and identify the aspects from the definition. So consideration means the person, the consideration must move at the desire of the promiser. It may be given, it may be supplied either by the promisee or any other person. It includes past, present, future consideration. It includes both positive as well as negative aspect of consideration. So these are the elements. Now let us discuss them one by one. The definition includes both positive as well as the negative aspect of consideration. Positive means to do something. Now let's say, for example, X offers to sell his house to Y for rupees 50 lakhs. It's a positive act, it's positive consideration to do something. Father has decided to sell his land because he needs money to get his daughter married. But the son says, father, don't sell the land. I will give you money for sister's marriage. So father agrees. He agrees not to sell the land, not to do something that is negative aspect of consideration. So father promises not to sell the land if son pays him the money. This is negative consideration. So what is the consideration for the son? Father's promise not to sell the land. That is negative consideration for the son, but it is valid consideration. Law includes the definition, it includes positive as well as negative aspect of consideration. What are the different words for negative aspect? Okay, so for negative consideration, what are the different words? Abstain, forbearance, not to do something, abstain. Okay, to abstain, to forbear, it means not to do something. That is a negative aspect of consideration. So these are the key words. Negative, it includes abstain or forbearance. Consideration means loss to one party, detriment to one party, gain or benefit to the other party. So the word loss actually means detriment only. Detriment means loss. So consideration means loss or detriment to one party, gain or benefit to the other party. Sometimes it may result in detriment to both. We will discuss this. Now, X promises to supply goods. Let's give a name to the goods, cans of juice. Okay. So he says, I will give you juice cans. And he says, I will pay you 10,000 rupees for it. Okay, he will give 100 juice cans. What is the consideration for X? If he's giving the juice, what is he getting in return? 10,000. This 10,000 is gain for X, but this 10,000 is loss for Y. Now, what is Y getting for that money? He is getting juice. This juice is gain for Y, but this juice cans, they are loss for X. So consideration is loss to one party, detriment to one party, gain or benefit to the other party. Sometimes it may result in loss to both. Pay attention. X and Y, they have decided to contribute 25 lakh rupees each and purchase the house of Z for 50 lakhs. Okay, now let me write this on a separate piece of paper for you. X and Y, they have agreed to contribute 25 lakh rupees each and use this 50 lakhs to purchase the house of Z. Now, X and Y, they are both paying 25 lakhs. This is loss to both. There are two agreements. One is between X and Y. There is another agreement between X, Y, and Z. So, between X and Y, you both are contributing 25 lakhs. This is loss to both. It cannot be gain to both. If both are gaining, there is someone who's losing. Okay, if both are gaining, it means there is someone who's losing money. So it can never be gain to both. Yeah, it can be loss to both, but it can never be gain to both. For someone to gain, there has to be someone who loses. There cannot be gain without loss. So there can be loss to both the parties, there cannot be gain to both the parties. So here they both are giving, they both are losing. Fine. So agreement between X and Y causes loss to both. Then what is the second agreement? This is the first agreement. This is the second agreement. X and Y, they are giving 50 lakhs and they are getting the house of Z. So what is the consideration for X and Y? House. Yes, they are getting the house. This house is gain for X and Y, but this house is loss for Z. What is the consideration for Z? 50 lakhs. This 50 lakhs is loss for X and Y. It is gain for Z. Yes. So there are two agreements. First is between X and Y only. It is causing loss to both. Second agreement is between X, Y, and Z. It is causing normal loss to one party, gain to the other party. Okay. So sometimes there may be loss to both the parties. It is still valid consideration. I hope you have written this. You have paused the video, right? Let us continue. So consideration means loss or detriment. Okay. Loss means detriment. They are the same. Gain or benefit to the other party. Sometimes it may result in loss to both. Consideration means something in return which need not be money only. Now, X gave goods to Y and he got goods in return. Barter. But both are getting something in return, na? It's a valid contract. X gave services and got money in return. Yeah, no problem. It need not always be good. Services are also covered in consideration. Let us now discuss the essential elements of valid consideration. So in today's session, we are only going to discuss the essential elements. In my next session, I will cover stranger to contract, stranger to consideration, and we will also discuss section 25, validity of agreement without consideration. Essential elements. Now the definition itself discusses the essential elements. Students, please note, if a question is asked in the exam on essential elements of consideration, you will have to compulsorily write the definition. So always start by writing the definition and then you will mention the essential elements of consideration. Now, the first part of the definition says, when at the desire of the promisor, it means that consideration must move, must. The word must always comes with promisor. The word may comes with any other person, that is promisee or any other person. Okay. The word must will always come with promisor and the word may comes with promisee. Okay. Now, consideration must move at the desire of the promisor. The act causing consideration must be done at the desire, at the request of the promisor. Any act done voluntarily or at the request of third party is not valid consideration. I'll give you examples to understand that. Let's say, for example, that there was a group of students and they were struggling in law. Okay, I was walking by, I saw that a group of students was struggling in law. I voluntarily went and helped them. I spent 2 hours in their doubt solving. After 2 hours, can I say, everyone, come on, give me thousand rupees? They may not be able to tell me, but in their mind, they are very clear, ma'am, we didn't call you, you came on your own. So, any act which is done voluntarily, you cannot demand consideration from the promisor. Now, this time I am very smart, okay? I saw these students were struggling in law. I did not stop. I was just walking and they stopped me. Ma'am, please, will you help us clear our doubts? I spent 2 hours in clearing their doubts. Now, can I ask money from them? Yes, because I have come at the request of the promisor. Then I can ask for money. They called me. Students called me. They requested. That is why I came. So now, because I have come at the desire, at the request of the promisor, I can ask them to pay. What if I come at the request of some third person? Okay, so let's say there is an ex student of mine and he tells me that, ma'am, I have a few cousins and they are struggling in law, will you please help them? So because of some third party, okay, because of the third party, I helped these students. Can I ask remuneration, can I ask consideration from these from these students? I have not come at their desire, at their request. I have come at the request of some third person. I can't ask money from them. Can I ask money from third person? Yes, if it is agreed. Okay. But here, since there was no agreement, I am doing it voluntarily. I cannot demand consideration. But if I agree with them that, yes, I will take money from you, I will go and teach them, but I will take money from you, then that is a consideration. So fine, all right, we can claim it. But here, as of now, I have not discussed anything, so there won't be consideration. Okay. Now, Any act or abstinence, abstinence means not to do something, because both are included in the definition. Any act or abstinence forming consideration must have been done at the desire or request of the promiser. Any act done voluntarily or at the desire of the third party is not valid consideration. There is also a case law, Durga Prasad versus Baldev. Let us go through the facts of the case. Durga Prasad was a zamindar. The collector of that particular area had requested Durga Prasad to collect money from various shop owners and construct a marketplace. Okay, he said, you construct a marketplace where these people will go and sell their products instead of selling it on the road. Now, Durga Prasad, instead of taking money from these persons, he built the marketplace by spending his own money. He built the marketplace with his own money just to please the collector. Many people occupied the shops. One of them was Baldev. Now they agreed that they will give commission to Durga Prasad on whatever items were sold by them. Okay. They promised, but then they did not pay him. So Durga Prasad filed a case. Now these people are arguing, why should we give you some percentage of our profit? We didn't ask you to come and construct the marketplace. You constructed the marketplace. You asked us to occupy shop. We did not ask you to build this marketplace. Why should we give you commission? So there was a case between them. What do you think? Should they pay commission to Durga Prasad? Answer is no. Now, they are the promisers because they have promised. Okay, they are promisers because they have promised to pay commission. Has the contract been formed at their request? Has the zamindar constructed the marketplace at their request? No. Durga Prasad has constructed the marketplace voluntarily. Any act which is done voluntarily is not valid consideration. If you have done it voluntarily, you cannot ask anything from them. But what if the shop owners had requested him, or maybe he had an agreement that I'm preparing this because you have asked me to do. So if there was an agreement wherein he was moving at their request, then yes, you can ask for consideration. But here, because he is doing it voluntarily, or you can also say he did it at the request of some third party, the promisers are not liable for commission. They are not liable to give any consideration. So there was no contract. He lost the case. Not very important for exam. So any act which is done voluntarily or at the desire of the third party, not promiser, okay, then you cannot claim anything from the promiser. It's not valid contract, not valid consideration. Consideration must move at the desire of the promiser, but it may be given, it may be supplied either by the promisee or any other person. Now, X had to pay 5,000 rupees to Y. Y is not concerned who gives him money. Let's say that Z had to pay 5,000 rupees to X. So X tells him that, listen, Z, first you will pay money, then I will give it to Y. Why don't you directly give it to Y, na? If Y accepts this arrangement, okay, if Y accepts, it is at the desire of Y. It is his decision. If he wants, he can claim it. Otherwise, he can say, no, I will take money from X only. So, but if Y agrees, he is not bothered who is giving consideration. Consideration may be given either by X himself or by Z. He is only concerned with money. He is not concerned with who pays him. So in this case, contract may be performed either by the promisee himself or any other person. Okay. So Y is not concerned who pays money. So long as there is consideration, it is immaterial who furnishes, who gives it. Consideration, although must move at the desire of the promiser, it may be supplied, it may be given either by the promisee or any other person. One very, very interesting case law, Chinnaya versus Ramaya. Okay, let us discuss the facts of this case. Chinnaya versus Ramaya. Please highlight this as very important for exam. You need to learn the facts also. Okay. In my full course textbook, I had shown it to you, I think. Yes. In my full course textbook, you will find that these case laws are also explained. I'll have to search for a case law. Okay. But these case laws, yes, see, the case law is explained in detail. So you can purchase this book from my website, capreetyagarwal.com. Now, let us continue. There was an old lady. Let us give her a name. A. Okay. So A was an old lady. She, by a gift deed, transferred property in the name of daughter R. Ramaya. Okay. A is an old lady. She, by a gift deed, transferred property in the name of daughter R. Ramaya on the condition that every year R should pay annuity. Annuity means annually some money. On the condition that you should pay annuity to my sister C. Chinnaya. Double A is an old lady. She, by a gift deed, transferred property to daughter R. Ramaya on the condition that every year R should pay annuity to A's sister C. Chinnaya. R agreed. And on the same day, she executed a deed in writing promising to pay annuity to Chinnaya. But later, she refused to pay. She said that I am giving her annuity, there is consideration for Chinnaya, but I am not getting anything in return from her because there is no consideration for me in this contract. No consideration, no contract. I will not give. Chinnaya filed a case. What do you think? Would she have won the case or lost the case? Think about it. Yes, I also agree that consideration is not moving from Chinnaya. But R got the property, no, from the old lady. Yes. Now you may argue that, ma'am, the gift deed had mentioned very clearly that there was a condition. So on that basis, Ramaya will have to pay. My dear students, that condition was imposed between A and R. If R fails to comply with that condition, A should file a case, not C. Okay. So there was a condition, but that was between the contract, that was a contract between A and R. My contract in consideration, what I am discussing is contract between Ramaya and Chinnaya. In this contract, there is consideration for Chinnaya, but there is no consideration for Ramaya. So how can this be a valid contract? Ma'am, we just discussed. Consideration must move at the desire of the promiser. Now, before I proceed, in case of the contract between Ramaya and Chinnaya, who is the promiser? Ramaya. She is promising, no, to pay annuity, and Chinnaya is the promisee. Consideration must move at the desire of the promiser. So here R on her own is promising to pay. She also executed a deed in writing. The consideration has moved at her request, but it may be given either by the promisee or any other person. Ramaya, you are not receiving any consideration from Chinnaya. but you are receiving consideration from the old lady. It doesn't matter who gives you consideration. It may move either by the promisee or any other person. Are you getting me? So, so Ramaya, you don't worry. You are getting consideration not from Chinnaya, but the old lady. You have got a property. So you also have consideration. This is a valid contract. You will have to. Ma'am, but in this case, contract between old lady and Ramaya. Ramaya is getting property, but old lady is not getting anything, na? Then no consideration, no contract. It's a gift deed. In gift, you don't expect anything in return. It is an exception to consideration that we are going to study next. Validity of contracts, valid even without consideration. Gift. You can't expect return gift. See, we ask for return gift, that is a different case. But you can't expect return gift. No. So you are giving a gift, you can't expect return gift. So this is a valid contract even though A is not getting any consideration. So gift is exception to consideration. So even though A is not getting anything from R, it's a gift, it's a valid contract. R, you are not getting anything from C, but you got it from R. No, you got the property, you got it from A. You got the property on the condition that you are going to pay money. So you have to abide by it. From this, we also come across a very important concept, stranger to contract. Stranger to contract or privity of contract. Privity means privacy. Only the parties to the contract can sue each other. A has promised to supply goods to B for rupees 50,000. Okay. A promised to supply goods to B for 50,000. Now A has already supplied the goods, but B is not paying money. A can file a case against B. Some third person, stranger, cannot sue. This stranger does not mean that a person you don't know, that wala stranger. No. Here the stranger means third party. Okay. Stranger to contract cannot sue. See, you have no business between the in the contract between A and B. तेरा क्या लेना देना है? Who are you? The contract is between A and B. If anything goes wrong, A can sue B, B can sue A. You are a stranger, you are some third party. You don't have any contract with either A or B. So, on what basis will you file a contract? See, only when you have a contract, you can file a case. You have no contract with either A or B. You are a stranger to contract. Stranger to contract cannot sue. But in my example, in my case law, C over here is stranger to consideration. This is a different concept. See, consideration is moving between A and R property. This is consideration. Property, consideration is moving between A and R. But C is also getting the benefit of that consideration in the form of annuity. So even though the consideration is moving between A and R, C, a stranger, is getting the benefit of that consideration in the form of annuity. C is stranger to consideration. And C is not getting the benefit just like that. C is getting benefit as a result of an agreement. R on her own wrote a contract and promised to pay money to Chinnaya. This contract is the very basis for the consideration. So because C is getting consideration as a result of a contract, C is stranger to consideration and stranger to consideration can sue. That is what we saw in the case law. Chinnaya filed a case, she even won the case. So stranger to consideration can sue. But stranger to consideration can sue only if C gets consideration as a result of an agreement. If there is no agreement, then C will be stranger to contract, and stranger to contract cannot sue. In that case, C would have lost the case. So there is a lot of importance to this deed in writing. See, I told you earlier also, C does not have any contract with either parties. That is why C is stranger to contract. But here, C has a contract with at least one of the parties, and because of that contract, C is receiving consideration. C is stranger to consideration. Stranger to consideration can sue. Please write one small note with me. If there is a deed in writing, or let me put it in different words. If a party, that is stranger, if a third party, that is stranger, receives benefit, right along with me, as a result of an agreement, then that person is stranger to consideration, and stranger to consideration can sue because you are receiving benefit as a result of an agreement. If a contract is for benefit of third party, but there is no agreement entitling him that benefit, there is no agreement, then that person is stranger to contract, and stranger to contract cannot sue. Okay, so if there is an agreement and you are receiving benefit as a result of an agreement, then you are stranger to consideration. Stranger to consideration can sue. There is no agreement, then you are stranger to contract, and stranger to contract cannot. So here, because there is a deed in writing, C is stranger to consideration, can sue. But if there was no deed, then C would have been stranger to contract, and stranger to contract cannot sue. Is it clear? So what is the difference between stranger to contract and stranger to consideration? What is the difference between? How to distinguish between stranger to contract and stranger to consideration? See, stranger to contract has no agreement with either parties. He's a total stranger. So A and B, they have entered into a contract. C is a total stranger. C cannot sue even if the contract is for his benefit. Cannot sue even if contract is for contract between A and B is for his benefit. Now, A is the father of P. B is the father-in-law of P. They both decide that we will contribute 1 lakh rupees each and pay it to C at the time of his marriage. A contributed 1 lakh. Okay, he paid 1 lakh to P at the time of marriage. But father-in-law did not contribute. Can P sue father-in-law? Answer is no. Even if the contract is for the benefit of P, He cannot file a case because he does not have a contract between, he does not have a contract with either A or B. Okay, he does not have a contract with either A or B. Contract is between A and B. If father-in-law is not contributing, who can file a case? A can file a case. Can P sue B? Can A sue B? Yes. Yes. A can file case against B because there is a contract. P cannot sue B. Even if the contract is for his benefit, he cannot, because there is no contract between P and B. So stranger to contract cannot sue. Cannot sue. That is also one difference, no? But stranger to consideration can sue. Here the stranger or a third party receives benefit as a result of an agreement. Okay, so stranger receives benefit as a result of an agreement. There is an agreement. Chinnaya versus Ramaya is the best example. A gave property to R on the condition that every year R should pay annuity. R agreed. On the same day, R executed a deed in writing promising to pay money to C. So although the consideration, the gift, is moving between A and R, C is stranger. But because the contract, or because C is receiving benefit as a result of an agreement, there is a deed. There is a deed. And C is receiving benefit as a result of this deed. C is stranger to consideration, and stranger to consideration can sue. So here the stranger receives benefit as a result of an agreement. If there is no agreement, then C is stranger to contract, and stranger to contract cannot sue. If there was no agreement, C would have lost the case. I hope you have written everything. Done. Consideration need not be adequate. See, consideration means something in return. It may seem adequate, it may seem inadequate. Inadequacy will not make the contract void. Now, X wants to sell his car to Y, actual car, not toy car, for 500 rupees. 500 rupees has value, na? My car, my wish. Law says that it is open to the buyer and seller to fix the price. It depends on how well the buyer can bargain. We are no one to decide the price for them. It is open to both the parties to decide the price. So law only wants the presence of consideration. They don't want adequacy. Okay, it leaves the people free to make their own bargain. 500 also has value. Consideration means something in return. It may seem adequate, it may seem inadequate. Inadequacy of consideration will not make the agreement void. Only in one situation consideration is considered, that is to decide whether the consent was given freely or not. Now, a Don started beating X. X got scared and he sold his house to the Don for 2 lakh rupees. The house is actually worth 2 crore rupees. Now we know that this is coercion. We know this is coercion. In case of coercion, the aggrieved party has two options. Either keep quiet, treat the contract as valid, or go to the court, cancel the contract, and once the contract is cancelled, it becomes void. Let's say that X goes to the court. The judge will ask him, what happened? He said, I want to cancel my contract. Why? I was forced to sell my house. Prove it. X will say, will I sell my house worth 2 crore just for 2 lakhs? I was forced to do so. That time, inadequacy of consideration will be considered as a piece of evidence. Okay, this will be considered as a piece of evidence to show that the consent was not free consent. Only that time inadequacy will be of use to us. Inadequacy of consideration will be considered as a piece of evidence to show that the consent was not free. Only at this time I will use inadequacy. Otherwise, you sell your house for 2 lakhs, 5 lakhs, 500 rupees. It is your house, your wish. I am not bothered. Consideration must be real. It must be of some value in the eyes of law. It must not be uncertain. See, here it looks like consideration, but actually it is not. Have you finished writing the above part? I want to erase it. You're finished. Now, X promises to cut grass in the garden of Y, and Y promises to pay him some reasonable remuneration. It looks like there is consideration. What is the consideration for Y? Grass is cut. What is the consideration for X? Some reasonable amount. How much? I don't know. It's uncertain. It looks like there is consideration, but actually it is not. It's not a valid consideration. It's not a valid contract. Consideration is illusory. Illusory matlab imaginary. It looks like consideration, but actually it is not. X wants to get his car repaired, so he goes to a mechanic. He tells the mechanic, I will pay you 1000 rupees, but if I feel like, my wish, my desire. Not if we look at the contract, there is consideration. For X, his car is repaired. For mechanic, 1000. But is there certainty that he will receive consideration? It only looks like consideration, but actually it is not. I will pay if I feel like. What is this? My wish, my desire. You may not get consideration. It only looks like consideration. Actually, it is not consideration. It is physically impossible to perform the contract. X tells Y, I will give you 2 lakh rupees. Y says, I will put life in your dead wife. Is it physically possible? X tells Y, I will pay you 5 lakh rupees. He says, I will bring a small piece of the moon, and while coming, I will also bring one star. All this can happen only in songs and movies. It's not real. It's physically impossible. It is legally impossible to perform the contract. X tells Y that I will sell you smuggled gold coins. It's legally impossible. Okay? Practically, you may do. It's legally impossible to perform. Entering into contract with minor, entering into contract for killing, these are all legally impossible to perform. There may be consideration, but it's not legal. Consideration may be either past, present, or future. What is the meaning of past consideration? Past consideration means consideration which has already moved. Let us highlight the keyword. It has already moved before the formation of the contract. Before is the keyword. So consideration which has already moved before the formation. But one thing, students, you need to know, it's extremely important. You need to know this. Past consideration is valid only if it moves at the desire of the promisor. Now, that is one requirement of consideration. It must move at the desire of the promisor. X asked a teacher, Ma'am, will you please teach my son? He's very weak in maths. The teacher taught the son for 1 month. The parent loved it. He said, Ma'am, you have done such an excellent job. I wish to pay. Now, let's say all this happened in the month of January. Then, in the month of February, X says, Ma'am, you have done such a brilliant job. I wish to pay you 5,000 rupees. The act is already done. Okay, this is already over. One party, X, has already received consideration. Your son has been taught. Other party will receive consideration after the formation of the contract. So, when one party has already received consideration before formation of contract, you have received your consideration, your son has been coached even before the formation of the contract. This is past consideration. And it has moved at your desire. You asked for the services, you asked for your son to be taught. A asked B to find his lost cow. B found the cow. A then promised to pay him 500 rupees as reward. The act of finding the cow is over. So A has already received consideration. B will now receive consideration. Now, B will receive consideration because he has acted at the request of the promisor. He has acted at the request of the promise. So he is entitled to consideration. So there is consideration for A which A already received before the formation of the contract. This is past consideration. B will get the reward after the formation. What is present consideration? In present consideration, only one party receives the consideration simultaneously at the time of formation of the contract. X sold a book to Y. He gave the book. Y got the book. Y promised to pay 500 rupees next week. Now, at the time of formation, Y already got the book. So, one party has received consideration, other party will receive in the future. One party that has already received consideration, this is present consideration, other party will receive consideration later. Ma'am, what if? Okay, what if? X gave the book. X gave the book. And Y gave money also. At the time of formation of the contract simultaneously. This is not present consideration. When both the parties receive consideration at the time of formation, that's not present consideration. This is directly, it is an executed contract. It is directly an executed contract. It's not consideration. Here it is not discussed. So if both get, okay, if both get consideration, he also got money, he also got the book. It's directly executed contract, it's not consideration. Future consideration means both will get after the formation of the contract, both, okay, both. Both parties will get consideration after the formation. So X promised to sell his car to Y. Car he will deliver next month. Y will make the payment 1 week after delivery. So both will get something in the future. It is future consideration. Consideration must not be something which the promisor is already bound to do. Mr. X lost his mobile, so he went to the police. What is the obligation of the police? To find the thief. His mobile is stolen now. X's mobile is stolen, so he went to the police. What is the obligation of the police? Find the thief. Now, X told the police, I will give you 5,000 if you find the thief. Even if you don't give, his obligation is to find the thief. This is not going to change the obligation. This is not valid consideration. Police found the thief. But X did not give 5,000 rupees. Can we claim 5,000 rupees? No, can't. This is not valid consideration. The police cannot claim it. X is a lawyer. What is his obligation? To win the case. Y tells him, if you win the case, I will pay you 5,000 extra. Are you're giving him fees na? It is his obligation to win the case. This extra is not going to change his obligation. This is not valid consideration. But what if I go over and above my obligation? Then can I claim? Yes. There were two brothers. They owned a coal mine, okay? There was some civil unrest. So they were worried that our mine will explode because of all that civil war. They went to the police. They told the police that we want protection. We have a coal mine. Don't worry. Police said, don't worry. There is a mobile van which will roam in your area. No, no, no. We want two stationary guards outside our coal mine. They said, you are asking for something extra. You will have to pay for it. We are ready to pay. After this war was over, the police presented them with a bill. They said, what bill? It is your obligation. You are supposed to protect us. We will not pay. You have to decide whether the police will be able to recover money. See, it was their obligation to take care. So there is a mobile van. They are not charging for it. But you asked for something which is over and above their obligation. For that, they can charge consideration. So for something which is already your obligation, there is no consideration. You need not pay anything extra. But if you go over and above your obligation, then you need to pay extra. Consideration must not be illegal, immoral, or opposed to public policy. Let's take an example for illegal. X offered to sell stolen goods to Y for 500 rupees. It's illegal. Smuggling, drug dealing. Okay, drug dealing, that is also illegal. Immoral. X, this is for immoral. X agreed to give a flat on rent to a prostitute for her trade. Knowingly, okay? This is immoral. It's against good morals, against your society, culture, upbringing, public policy. X agreed to give donation to a school and the school agreed to give admission to his son. See, the deserving candidate will be left behind and one who is ready to pay donation, he will get admission. This is against the well-being of the society. You cannot let deserving candidates lose to someone who is ready to pay money. So it's against the society. All this will make the consideration unlawful, not a valid contract, not valid consideration. The school took the donation but they did not give admission. X cannot file a case, can't file. So students, these were the essential elements of consideration. We discussed each one of them in detail. We also made notes. I hope the concept is clear. We will continue in the next session.